Miss Langford, please stand. The room had been loud 5 seconds earlier, papers moving, a cough in the back row, the low scrape of a chair. Then Judge Helen Westcott said those four words, and Courtroom 5B in Fulton County went dead silent. Vanessa Langford rose slowly in a cream blazer that cost more than most people's rent, her hands folded so tightly in front of her you could see the tendons in her wrists. She had spent 14 months arriving at court with polished statements, elite counsel, and the same expression wealthy defendants wear when they still believe the real verdict is being negotiated somewhere off the record. Then the judge looked over her glasses and said, "Your money did not lessen what you did, it documented it." That was the moment her face changed, not when the jury convicted her, not when the press started calling her the Buckhead hit-and-run heiress, not when the state froze two of her accounts. This was different, because in that instant she understood something too late. The money she had used her entire adult life as a shield had become the prosecution's map, every wire, every favor, every quiet payment, every arrogant assumption. It was all sitting in labeled exhibits 5 feet from the bench, and what looked at first like one rich woman's late-night crash had turned into something much uglier. A case about obstruction, influence, staged narratives, bought silence, and one judge who refused to confuse privilege with remorse. If you appreciate stories where power finally meets consequences, stay with me, because this one did not collapse all at once. It cracked in layers. It began on the night of June 14, 2024 at 11:42 p.m. in hard summer rain on Piedmont Road. Daniel Ruiz, 27 years old, was stopped at a red light in a white Toyota Corolla with a magnetic sign on the door for MedNow Pharmacy Courier Services. He was on his second job of the day, delivering after-hours medication across Atlanta. His 4-year-old daughter, Luna, was asleep at his mother's apartment in Marietta, waiting for him to come home. Vanessa Langford was coming back from a private fundraising dinner at the Arden Club 3 miles away. 43 years old, founder of Langford Capital Advisory, regular on charity boards, frequent quote in business magazines. The state later proved her black Range Rover was moving at 73 miles per hour in a 35 when it clipped the median, crossed one lane, and drove straight through the rear of Daniel's car. The impact shoved his Corolla into the intersection and folded the trunk into the back seat. She didn't stop. That alone would have been enough to destroy an ordinary person. But Vanessa Langford was not ordinary, and that was the problem. At 12:03 a.m., at 21 minutes after the crash, she pulled into the underground garage of the Halcyon Residences, where she owned a $3.8 million penthouse. Security cameras showed the front end of the SUV crumpled, one headlamp hanging, steam lifting off the hood. The doorman later told investigators she was shaking and kept saying, "Call Adrian, not 911, Adrian." Adrian Sloan was not a relative. He was the family fixer, former crisis consultant, former lobbyist, the kind of man wealthy clients hire when what they need isn't help, it's insulation. At 12:19 a.m., Sloan arrived. At 12:31, the SUV was moved to a private detailing warehouse in Chamblee, connected to one of Langford Capital's vendors. At 1:04 a.m., Vanessa's executive assistant received a text from Vanessa's phone that said, "Nobody talks until legal reaches out." The defense would later claim she was in shock, panicked, disoriented, not thinking clearly. That argument lasted until investigators stopped looking at the crash and started looking at the money. First came the obvious. Parking records from the Arden Club showed Vanessa had her fourth vodka at 10:57 p.m. Then cell site data placed her on Piedmont at the exact minute of impact. Then an emergency room toxicology screen taken nearly 4 hours later after her attorney arranged a voluntary medical visit still showed a blood alcohol level above the legal limit. That should have been the end of it. It wasn't, because Daniel Ruiz did not die at the scene. He died 36 hours later at Grady Memorial after surgeons tried and failed to stop the internal bleeding. And once his family spoke, the case changed shape. His mother described getting the call at 12:11 in the morning. His sister described explaining to Luna why her father wasn't waking up. Suddenly, this was no longer a traffic story with a luxury defendant. It was a moral test. A man had been left dying in an intersection while the person who hit him arranged strategy in a parking garage. Then investigators found the detail that changed everything. 3 days after the crash, Langford Family Foundation issued a $50,000 community assistance grant to a nonprofit nobody in Daniel's neighborhood had ever heard of. That nonprofit's director turned out to be the cousin of a witness who had seen Vanessa climb out of the driver's seat. A week after that, $18,750 moved from a Langford Capital operating account to Sloan Strategies LLC, memo line, emergency consulting. 2 days later, another payment went to Northridge Auto Restoration, the warehouse that held the damaged Range Rover before police could inspect it. On paper, each transaction looked polished, professional, almost boring. Together they looked like consciousness of guilt. Subpoenas widened, emails surfaced, deleted texts came back. Her assistant, Marissa Klein, 31, folded first. She took immunity and handed prosecutors a chain of messages from 12:47 a.m. to 2:16 a.m. One line froze the courtroom when it was read aloud months later. "We need to keep this at accident level, not criminal level. Not fear, not confusion, strategy." And Vanessa made a terrible mistake that wealthy people make when they've been protected too long. She assumed the system would respect her image more than it respected the evidence. She hosted a sympathy-heavy interview through counsel. She emphasized her philanthropy. She offered to fund a traffic safety initiative in Daniel Ruiz's name before arraignment. She donated $250,000 to a trauma charity the same week her lawyers argued for bond leniency. It was presented as generosity. The judge saw it for what it was: choreography. If you believe no one is above accountability, stay with me, because the middle of this case is where the illusion died. The prosecution introduced a spreadsheet recovered from Adrian Sloan's laptop. The file name was bland enough to sound harmless, June response, but the columns were devastating. Date, payee, amount, objective. One row listed Northridge Auto Restoration, $12,800, vehicle containment. Another listed Falcon Media Group, $2,700, narrative stabilization. And then the line that changed the air in the room entirely: De Ruiz family intermediary and hold pending, not condolences, not responsibility, not grief, an intermediary. The defense objected. Too prejudicial, too speculative. Judge Westcott overruled. And then came the surveillance footage from the Halcyon garage, cleaned and enlarged by the Georgia Bureau of Investigation. Vanessa steps out of the SUV in heels, looks directly at the crushed hood, and says, clear enough for the jury to hear, "Can this be handled before morning?" That was when the story stopped being ordinary, because now the jury was no longer looking at a rich woman who made a horrible decision after drinking. They were looking at a defendant who understood exposure instantly and moved with cold precision to buy time, buy distance, and possibly buy people. Intent no longer had to be guessed. It had an audio track. By the time closing arguments arrived in February 2026, the defense had narrowed its entire case to one plea: do not let anger at wealth become extra punishment. But that line collapsed under the weight of the facts, because Vanessa Langford was not being punished for having money. She was being judged for how she used it. The prosecutor said it plainly: this was not privilege in the background, this was privilege in action. The jury convicted her on felony hit and run, vehicular homicide in the first degree, tampering with evidence, and attempted witness influence. Still, even after the verdict, she thought there was one last exit. Her legal team filed a sentencing memorandum thicker than a phone book. They attached letters from board members, surgeons, museum directors, former elected officials. They proposed restitution beyond the statutory requirement. They highlighted therapy, rehabilitation, charitable commitments, family dependence, community standing. In other words, they tried to convert wealth into virtue one final time. Judge Westcott read every page. Then she called them what they were: an expensive argument for unequal mercy. On sentencing day, Daniel Ruiz's mother spoke first. She did not cry. That was the devastating part. She stood straight and said, "My son died in the dark while she arranged her mourning." You could hear someone in the gallery exhale sharply. Vanessa looked down. For the first time in the entire case, she stopped performing sorrow and seemed to feel something closer to fear. Then the judge delivered the kind of ruling people remember for years because it is not theatrical. It is precise. 12 years in state prison. No suspended sentence. 5 years probation after release. Full restitution. Immediate surrender. Separate referral for review of foundation-related financial irregularities uncovered during trial. The court also ordered the seizure review of assets directly tied to obstruction payments. Vanessa's knees visibly buckled when the deputy moved toward her. Adrian Sloan, already facing his own charges, stared ahead without blinking. Marissa Klein left through a side door under escort. And in the front row, Daniel's sister finally put her hand over her mouth and cried into her coat sleeve. Not because justice brings people back, but because after 2 years of money, delay, headlines, and legal smoke, somebody in authority had finally said what the whole case had been about. No, not here, not this time. The fallout kept spreading. 2 nonprofit boards removed Vanessa's name from donor walls. Langford Capital lost institutional clients within a week. The foundation she used as a moral backdrop went under forensic audit. And every polished thing that once made her untouchable became part of the record against her. The gala photos, the concierge doctor, the private garage access, the consultant invoices, all of it. That is why this story matters beyond one defendant in one courtroom, because cases like this reveal something uncomfortable about power. It usually does not announce itself with violence first. It announces itself with confidence, with assumption, with the belief that rules are flexible if your bank balance is large enough and your circle is important enough. The crash was catastrophic, but the deeper crime was the certainty that the damage could be managed. It couldn't. And that is the image that stays with you. Not the penthouse, not the Range Rover, not the headlines. It's the final walk, the click of expensive shoes slowing on courtroom tile, the sound of a deputy saying, "This way." The woman who thought cash could bend consequence discovering, in public and all at once, that money can buy delay, lawyers, handlers, even silence for a while, but it cannot buy innocence back once the evidence learns how to speak. If cases like this make you think, let me know in the comments. Because the most satisfying part was never watching wealth fall. It was watching the law, patiently and without theatrics, refuse to kneel to it.